The following segment is sponsored by GILMAN Bedigan.
The U.S. Supreme Court recently announced it would be hearing a case challenging a New York law that requires applicants for a concealed carry permit to show proper cause for needing the license. Opponents say being denied a permit violates their Second Amendment. What the justices decide will have implications for Maryland. Attorney Charles Gilman with Gilman and Bedigan joins us this morning. Good morning.
Good morning, Patrice.
So as it stands, you have to show proper cause to have a carry permit. What would you have to demonstrate?
Well, you have to demonstrate substantial need for it. In Maryland, it's a shall issue state, so you have to go in, you have the burden of proof to show the board and the Maryland State Police who issue the carry permits that there's a substantial and good reason why you need to be able to carry a concealed weapon.
So the law doesn't stop you from having a gun. It just says that you can't walk around with it unless you're able to get that permit. Is that a violation of Second Amendment? That is what is at the crux of this debate.
You know, Patrice, there's people on both sides of the extreme. Many traditionalists will say that, yes, that violates the Second Amendment. But the Supreme Court interpreted it in 2008 to mean that just because the Second Amendment says you have the right to bear arms doesn't mean that states can't put a qualification on that right to bear arms, such as Maryland, like show us a substantial need, then we'll let you carry your gun. So you got to balance that.
All right, so putting you a little on the spot here, give me an argument for either side. If you had to make the argument for either, what are they going to be presenting to the court?
Well, I believe Maryland's fairly liberal. Maryland's shall issue permit statute's very liberal. I think in Maryland, for example, if you can prove that you handle cash or that you have a business or that you do things that are dangerous in your loan, they'll most likely issue that permit. They may issue it with restrictions. Whereas you can only carry it at certain times of the day, when you're at work or in the course and scope of your employment. I think the Supreme Court, based on what they did in 2008, now granted the makeup of the Supreme Court is very different now than it was in 2008, but I think the 2008 case will not be overturned based on this New York case. I think the states will still be given the ability to shall issue permits, not have to issue permits.
In the long run, you think we're more or less safe with everybody being able to carry guns if it goes that way?
Well, Patrice, again, there's two sides to that argument. Yeah. I've always, look, if everybody's got a gun, everybody's going to probably be more careful. But if you have a lot of people with guns and a lot of people without guns, society may not be balanced. And you want to, we've seen a lot of mass shootings recently. And it turns out in hindsight that a lot of those mass shootings aren't guns that people would be carrying with a permit anyway. Mm-hmm. But the point is you want to keep the guns away from people that shouldn't have them and that pose a risk to society. So the vetting process, the May issue, hopefully will help vet out the people that are okay to carry guns and those that may be a little volatile and not okay to carry guns.
All right, Charles, tough questions there. I appreciate you trying to tackle them for us. Thank you.
You got it, Patrice.